I was actually going to mention all his CV, but I think this is quite unnecessary. People very well know him. A lot of people here studied with him at King's College, either in London or online. So I think I don't necessarily need to introduce him. What I think it's good to say is that just to remind you all that this is going to be a 3-day course of 1 hour and a half. The idea is to stop sharply at noon our time. And the first day, which is today, Professor Whish is going to talk about Article 101. On the 24th, next week, he's going to talk about Article 102. And on the 30th, he's going to talk about merger regulation. Professor, for your knowledge, we have here, we had this morning 127 people participate in the event. It's good because we have all the traditional law firms, we have new law firms in the competition arena that are actually participating as well. We have the economic consultants. We have companies. So we have at least 3 companies I noted, Braskem, Raizen, and Itaú. They are participating. We have universities. So we have University of São Paulo, Unisociesc, University of Paraná, University of Vale do Rio Doce. We have CADI, our antitrust authority, with more than 20 people also watching the event. We have our colleagues from Argentina, from Orval. We have people from the Congress, Brazilian Congress, watching the event. So I think it's quite a unique and diverse team watching your lectures today. So without further delay, I just want to thank you once again for making yourself available for the course. People are, every year, people ask us when it's going to be your course. Unfortunately, we couldn't have you physically here in Brazil this year, but at least we're going to watch you through the screen. So it's 2 years since you came last time, or 3 years, I think, since you came last time for the course. So it's a pleasure to have you again. And hopefully, and I'm sure about it, we're going to have a great event once again. Thanks, Professor.
Oh, thank you, Bruno. It's a very kind introduction. I wish desperately that I could be with you in Sao Paulo, or in that beautiful place where that conference was held 3 years ago, whose name I can never actually remember, but it had fantastic araucaria trees, I seem to recall. Well, what an amazing audience, 110 of you at the moment. I know that there are lots of people here from the authority, who I see are yet again in the top 10 authorities in the world. I just read that this morning. Many congratulations to you. Of course, I have printed off the Brazilian Competition Act for when you start asking me difficult questions. And I've also got here a list of the attendees, and it's a very impressive bunch of people. So yes, 3 lectures. And I thought I'll just talk about Article 101 today. I said to Bruno earlier that it's not been a bumper year in terms of decisions and Article 101 judgments, but I think there's enough here to keep us going for 90 minutes, possibly not the full 90 minutes. We'll see how we get on. So I hope you've got access to my handout, and all I'm going to do today is to cover pages 2 to 8, looking at what the Commission has been doing in terms of enforcing Article 101, and then looking at appeals that have gone to the General Court and the Court of Justice.
Professor, just excuse me to interrupt you, but sure. Just to tell everyone, your mics are going to be muted, but please leave your cameras on so Professor can actually see our faces. And do send questions in the chat room, which is going to be open, and Professor is going to try to address that at the best moment, please. Sorry, Professor.
No, that's fine, but do keep the cameras on, because those of you that I taught will know I don't like it when people get out their newspapers halfway through the lecture and start. Yes, if you have any question, any comment, just put it into the chat box, and then at an appropriate moment I'll stop, pause, read the question, and I'll address it, and then you or Bruno can unmute you if it's appropriate to have a chat. So, pages 2 to 8. Now then, most of this is about horizontal agreements. Overwhelmingly, the European Commission, when it's applying Article 101, is above all concerned with horizontal agreements of various kinds. I've got some material on vertical agreements, but it's much thinner than the horizontal story. So the way my handout goes is pages 2 and 3, I just list the current investigations that I'm aware that the Commission is undertaking in relation to horizontal agreements. Then pages 3, 4 and 5 are about appeals to the General Court, and then pages 5 and 6 are about cases that go on to the Court of Justice. Now, first of all, on pages 2 and 3, there is a list there of investigations that I know that the European Commission is conducting. And the reason I know that it's conducting these cases is that it is based on press releases that the Commission itself has published. And so what happens in Brussels is that, first of all, if they do a dawn raid in a sector, they will normally issue a press release to say that they've done a dawn raid. Then if they formally initiate proceedings, there will be a press release. And then when they proceed to a statement of objections, again, there will be a press release. So all of this is based on stuff that is officially in the public domain. And if you look through the list, you'll see there's a whole variety of different sectors under investigation. Many of these cases I know almost nothing about, because all the Commission does is to say, we've done a dawn raid or we have initiated proceedings. They don't necessarily tell you very much. But there are a few of them that I think raise some quite interesting points of legal analysis and policy. And I thought I would just pick those cases out. And I'll explain why I think the case sounds interesting. And then if you want to come in and say anything, then by all means do. So if we go down page 2, the first one I thought I would say something about is the 9th one down, I think, motor car insurance in Ireland. A lot of these cases are basically typical cartel cases. But motor car insurance in Ireland is sort of conceptually a somewhat different kind of thing. And what the Commission is doing here is investigating the trade association in Ireland that represents car insurers. And that entity is called Insurance Ireland. So you've got lots of insurance companies and brokers like Campion Insurance and Wright Insurance Brokers, but sitting above them is the association Insurance Ireland. And what's happening in this case is you've got all the insurance companies and brokers, and of course they have a lot of information about individuals' claims history. So there may be somebody who's several times made claims that the car's been damaged and he or she is seeking insurance payments, compensation. And of course, it's perfectly possible, and indeed often is the case, that there's something fraudulent or dishonest about the application that has been made. So individual insurance companies know about these claims and the honesty or dishonesty of the person in question. So each individual company has that information, and then they submit it to Insurance Ireland. So therefore, Insurance Ireland is operating a data pool. In competition cases nowadays, we're always talking about data and big data and so on. So Insurance Ireland controls this data pool of information about fraudulent claims. And then the insurance companies who have submitted the data to Insurance Ireland can receive back the pooled data. And so it is possible for company X to discover that clients of company Y had made dishonest claims. And so, of course, company X will then take that into account when quoting a premium for next year's insurance, because the dishonesty of the person in question is going to affect the premium price, or indeed you might decide not to insure them at all. So that's fine. That's a data pool. And the Commission says we've got no objection to the operation and the existence of a data pool such as that. In fact, it makes the market more transparent, and it means that the insurance companies can kind of do their business more efficiently. But, and then this is the interesting point, there are other insurance companies outside Ireland who wish to enter the Irish insurance market. And so they go to Insurance Ireland and say, please, can we have access to that data? And I'm not sure precisely on the facts what happened. I don't think Insurance Ireland refused to make the data available, but I think what they do is make the data available to the third-party insurance companies on, in inverted commas, discriminatory terms, which effectively means that they aren't able to access the data in question. So if that is what is going on, effectively it's a kind of collective boycott, because here you have the essential information for operating efficiently on the Irish market, but it is being denied to third-party would-be entrants to the Irish insurance market. Now, I mean, the case is still being argued, and without knowing anything more about it, one can absolutely assume that Insurance Ireland will be saying that we're either not refusing the data, or we have objective justification for the terms on which we would or would not offer that data. And of course, the complainants will say, no, this is effectively a collective boycott. So we'll wait and see what comes of it. But I think it's of interest, A, because of this data pooling phenomenon. Data pooling in itself, innocent, but can there be circumstances in what you do with the data becomes unlawful? And it's also interesting because, as I'm going to show you with a couple of the other cases that the Commission is doing, you always have this difficult thing with competition law analysis, especially with horizontal agreements. You've got something over here which is obviously a cartel, and then you've got something over here which is cooperation, which is obviously good because it's a good way of developing a new product, a new vaccine to deal with COVID-19. So you've got good cooperation, bad cooperation, but then you've got all these things in the middle where it can be very, very nuanced to tell whether something is pro or anti-competitive. And here, as I say, the Commission says we've got no problem with the data pooling. On the other hand, we do have problems if that data is not being made available on reasonable terms to third parties. So that's what I wanted to say there. I've had a question from Daniel. Can I tell from the press releases which ones are the international cartel cases? It's a good question. Now, when you say international, do you mean international in the sense of being beyond Europe? In other words, you're asking, are there any clients out there that I could get for Brazil? I'd never actually thought that. I'd never even thought of that issue, but I can answer it just by having a quick look through. It's an interesting question. Do you know, in the past, obviously, there's been things like refrigerator compressors and maritime car carriers and power cables, which were very international cartels. I have to say now, just looking through that list, I think that they are not international cartels of that kind. Okay? They are becoming rarer and rarer. Is that because they're being hidden more effectively, or is that because of the combined enforcement action of the competition authorities around the world, coupled with the follow-on actions for damages that you now get, is causing people at last to say, God, is this really worth it? I think it's a very interesting question. And I don't know what the position is in Brazil now, but the way in which legal practice in Europe has changed because of the follow-on action for damages is absolutely incredible. And I've only sent you my EU handout, but when I'm using this handout in other circumstances, it is EU and UK, and it is literally twice as long. And quite a lot of that is because of so many utterly fascinating damages claims that are being brought against the international cartels in the courts of England and Wales. So it's a very fascinating thing to watch in this day and age. Okay, right. Now then, if we go, oh yes, 2 down from that, German car manufacturers. And I think this one is very interesting, again, in the same sense of when do you have horizontal cooperation that's perfectly legitimate, and when does it tip over into something that can be regarded as cartel-like? And this is an investigation of BMW, Daimler, and Volkswagen. And it is not an investigation of a conventional price-fixing, market-sharing cartel or anything like that. Rather, the Commission says that these 3 German manufacturers, which is basically the whole of German car manufacturing, because VW is also Porsche and Audi, that they have technology that can be used to suppress, in the case of diesel car engines, they've got technology that can suppress the emission of nitrogen oxides. And in the case of petrol, they've got technology that can prevent the extrusion of particulate matter. And so these companies possess this technology, clever technology, terribly important from an environmental perspective and so on and so forth. And the Commission says they got together and over many years, in one case from 2006 to 2014, and in the other from 2009 to 2014, they got together and agreed the extent to which they would apply this technology to their cars, which is another way of saying that they agreed to restrict the extent to which they would use this technology in their cars. In other words, they were in a position to compete with one another on better environmental standards, but that comes expensive, and so they entered into agreements to limit the extent to which they would make use of that technology. And the Commission says, well, this is cartel behaviour. And the Commissioner, Margrethe Vestager, gave a speech last year and said, when we talk about cartels, we don't just mean price fixing, we don't just mean customer allocation, we don't just mean market sharing. There are other ways of restricting competition as well, and especially when there's important technology and companies decide to suppress the use of that technology. Now, a couple of things I'll say about the case. Firstly, the Commission knows perfectly well that these car companies do regularly meet in industry fora in order to discuss standards, technology, developments, etc. And they do discuss with one another things like seat belts and airbags and how they work in the event of an accident, and they adopt common standards on those kind of things. And it's in the context of those kind of meetings that the car manufacturers also discuss their technology for suppressing particulate emissions. And it's almost like the exam question, as it were. Here are these companies meeting regularly to discuss the following 10 things. And the Commission says, we're not worried about most of it at all. It's all very good. But when it came to this is cartel-like behaviour. And so this goes to this continuum I'm talking about earlier. Obvious secret price fixing, bad. Developing a new vaccine, good. And then a load of other stuff along this line. And where are you in terms of the line in the sand? And suffice it to say, in this case, the statements of objections have been sent. The replies went into the Commission in December of 2019. I've not heard anything about the case since. I do not know whether there's been an oral hearing yet, though if there had been, I think I would have heard. But I do know that BMW has made provision in its accounts of 1.4 billion euros for the fine it expects to have to pay in due course. Of course, they will then say it's completely ridiculous, Commission, and there will be an appeal. But nevertheless, they've obviously had the legal advice. I think you're going down here, and I think this is the kind of level of fine that you're likely to have to pay. So I think that one's an interesting case to watch out for as well. I assume it should be near to completion. I dare say COVID-19 has messed things up somewhat, but the case has been around for a long time now, so we can expect a conclusion. For the practitioners, well, practitioners and Kage, metal packaging, there's just a funny little point to think about in metal packaging for anyone who ever gets involved in a cartel investigation in Europe, that the German competition authority, the Bundeskartellamt, was investigating a metal packaging cartel. And then, as I say, at the foot of page 2, the Bundeskartellamt started the investigation, and then they closed their investigation in April of 2018, and the case was transferred to Brussels. So the BKA closes the case down, and then the European Commission opens the case. And Silgan says this is completely improper. I mean, this case was more or less ready to be decided by the BKA, and then all of a sudden it transfers to Brussels. And so they've tried to get the Brussels case discontinued. And as I say at the top of page 3, that attempt to stop the case in Brussels and have it repatriated to Germany has failed. Why are Silgan agitated about this? As I understand it, is because in Germany there were different limitation rules as to the imposition of a fine, and because they had applied for leniency in Germany, but different limitation rules apply in Brussels, and they had not applied for leniency in Brussels. So obviously, if the case continues in Germany, they get one solution, but if it proceeds in Brussels, they get a different solution. So apart from anything else, it shows you that if you're ever blowing the whistle in Europe, you should buy at least 2 whistles, because you may need immunity. Well, you don't know at the start of the thing where you need immunity. And there have been cases in the past where somebody blew a whistle in Brussels, but couldn't afford a second whistle for Italy, and then ended up being fined in Italy because they hadn't blown the whistle twice. So it is this whole nightmare thing of international whistleblowing that I'm addressing there. Then the first bullet point on page 3, I'm just going to say to you, note styrene monomer purchasing. It's the word purchasing I'm stressing, and I'll come back to it. If we go down to the 5th bullet point, French grocery retail sector, this is a case that the Commission is doing in relation to French supermarkets. So you've got the Casino Group and Intermarché, they're groceries chains in France, and they have a purchasing alliance. Many of you will be familiar with this idea. Typically in the grocery sector, you have a purchasing alliance. So you go to Procter & Gamble or Coca-Cola or Kimberly-Clark or whatever, and you hope to be able to extract lower prices because of the group power that you have given to yourself through joint purchasing. And as a general proposition, competition authorities are perfectly sympathetic to group purchasing if what it means is that you get lower prices upstream and then you compete those lower prices downstream to us, the consumers. And the Commission has got horizontal cooperation agreement guidelines, and there's a specific section on group purchasing, and it says more or less what I've just said. And yet here we discover that the European Commission has done dawn raids on Casino and Intermarché because the Commission doesn't like the way that this joint purchasing organisation is operating. Incidentally, in this case, I do know that the joint purchasing was being done by a joint venture of Casino and Intermarché. So this whole thing is set up legally with a special vehicle to do the group purchasing. The JV has since been disbanded. But what the Commission's theory of harm is that you've got the joint purchasing, which in itself may be perfectly okay, but through the contacts they have in the JV, they get to communicate to one another their plans in relation to their downstream activities. So you have, as it were, a spillover from the upstream good cooperation into understandings on downstream prices and also, as I understand it, which outlets they are each going to open in which localities. So that's what the Commission is looking at. And I've noticed that in 2019, the French authority looked into the same phenomenon. A number of group purchasing organizations, and in particular, there was one involving Tesco and Carrefour on the French market. And on the same day that the European Commission did the dawn raids in the case I'm talking about, the Belgian Competition Authority did dawn raids on Belgian grocery chains. In other words, therefore, these competition authorities, there's a kind of a joined up policy there of looking at these purchasing organizations. And I don't know whether there's anything like it in Brazil at the moment, but what is being discussed within the ECN in the EU will, of course, also be discussed by competition authorities in the context of the ICN as well. I mean, these things go round the global village of competition policy very quickly in this day and age. Okay, so that's the end of the current investigations that I'm aware that the Commission is conducting. I've then got two cartel decisions. I repeat, if you've got any questions, comments, just put something in the chat box. Two decisions, neither of them particularly exciting, but the first one in September of last year, fines of 31 million euros for the canned vegetable cartel. I often have said in my life, is there nothing that people won't cartelize? I mean, we know cement, chemicals, construction. I mean, that's where these things happen. But canned vegetables, well, it happens. And interestingly, actually here, if you go to the top of page 4, I mentioned that this follows the canned mushrooms decision of a couple of years ago. And in that decision, a company called Bonduelle was fined for being in the canned mushrooms cartel. And then if you go back to page 3, my second bullet point, in this case, Bonduelle was the whistleblower. And I don't know, but one assumes that this is one of these cases where the Commission does a dawn raid because it's had a tip-off and finds that Bonduelle is in a canned mushroom cartel, and then Bonduelle, I imagine, then does some sort of internal audit and says, what the hell's going on here? And then, of course, as can happen, you discover that there are other of these cartels within the organization. So it's quite interesting. They were fined for the mushrooms case. And then the second bullet point, the commission says in this case, they blew the whistle. But if they had not blown the whistle, they would have been fined 250 million euros. So from a competition authority's point of view, that looks like a good piece of work. Do an investigation, make people realize that there are illegal things going on, cause them to blow the whistle, and then you publicize the fact that they would have been fined 250 million euros, but they weren't because they blew the whistle. And also note, this is a cartel that lasted for 13 years. What did they actually do? They fixed prices, they agreed market shares, they allocated volume quotas, they allocated customers, they allocated markets, they coordinated replies to tenders, and they exchanged personal confidential information. So what I should have said is, what didn't they do? Because that's the kind of A to Y of illegal things. The only thing missing there is a collective boycott. Maybe they forgot to do it. So, you know, it's the full gamut of illegal behavior. Reduction in one penalty because of inability to pay. I don't know if that happens in Brazil, but you do get cases where sometimes you have SMEs and you calculate their fine, and there's actually then a danger that you might, well, possibly put them out of business, or at least you might make life very, very difficult for them. And there is a system in Europe where you can plead inability to pay, and sometimes you do get reductions. I also see that the Commission during COVID-19 has been a little more generous in terms of the duration or the period within which the penalty has to be paid. So that's that one. And then we got ethylene. So this is an interesting one because, as I say there, this is a purchasing cartel. So on page 3, I mentioned styrene monomer purchasing. Then we've got the French groceries purchasing. And here we've got a fine on the ethylene producers for agreeing to limit the prices that they would pay for, not the producers, the users of ethylene, agreeing to limit the prices that they would pay to their suppliers. So it's a purchasing cartel, and the fine is a very significant one, 260 million. It would have been over 400 million, but for the fact that Westlake was the whistleblower. But what is interesting with purchasing cartels is, what's the theory of harm? Because if you go back to my joint purchasing that I was discussing earlier, you can have an open joint purchasing organization which negotiates prices, and then you try to transmit those low prices on into the downstream market. Here, it's a secret cartel simply trying to get the price to the ethylene sellers as low as possible. Well, what's the theory of harm? Is the theory of harm that we're harming the ethylene sellers? Because if it's all about consumer welfare, surely the only thing we're concerned about is the end price in the downstream market to the consumer. So what's it got to do with the upstream ethylene sellers? Well, all I can say is that the Commission says this is a cartel that operated to the detriment of the ethylene sellers. So whatever that theory of harm is, it's not an explicit theory of harm to consumers, because consumers are down there, the sellers are up there. And I just note that there seems to be much more interest around the world, actually, in these purchasing cartels nowadays. I wonder if this would have happened 10 years ago. I simply do not know the answer to that. I'm just raising the point. So that's that one. Then we get to the General Court. And the first case, car battery recycling, lots of these judgments are simply about facts or simply about the level of the fine. and there's nothing of interest to them whatsoever. And I can't see anything interesting about this case, so I'm not going to talk about it, other than to say it was a purchasing cartel again. But it all goes, the actual judgment is about the fine. What is of interest is the next one, euro interest rate derivatives. And you'll be aware that in Europe, we've been looking at these benchmarking cases for a long time now, where in financial services markets, where you have things like hedging, contracts, forward agreements, derivative agreements, interest rate swaps, etc., mortgages, very often these financial instruments are priced by reference to a particular benchmark, which could be LIBOR, Euribor, Yenbor, whatever. And the point about these things, this one is about Euribor, so I'll talk about Euribor. What happens with the Euribor is, so it used to happen, that every day a Euribor exchange rate is created. And basically the idea is that this is the interest that would be paid on a loan by one prime bank to another prime bank on that particular day. So I'm Barclays, I'm lending money to Citibank in wholesale markets. What is the interest rate for that on the, whatever it is, 15th of September 2020? And so you generate these rates, and the way it's done is that a number of banks submit the amount that they're having to pay in the international money markets today between 10:45 and 11. I am paying 1.78%. That's a factual matter. I submit it to Thomson Reuters, and 46 other banks also make their submissions. And then out of that, Thomson Reuters works what the rate is for that day, and this is published. And then all those contracts that mature on a particular date by reference to that day's Euribor, the Euribor exists there as an objective fact generated on that date. And there are lots of these benchmarks. In fact, it's infinitely more complicated than I've just explained, but that's the essence of the idea. So what we can say, therefore, is that the Euribor, that's the borrowing rate for euros, or the LIBOR, or the borrowing rate for pound sterling, or the Yenbor, these are intended to be objectively created, and so they are a public good, by reference to which trillions of dollars of trade is transacted. So it has to be objective and verifiable and true. Okay, fine. Then the banks who are making the submissions also have traders who are entering into these exotic financial instruments. And so in a sense, the bank is conflicted, because you've got the bank contributing to the formation of the public good. And at the same time, you've got traders who themselves are exposed in their derivative agreements or whatever to the very Euribor or Yenbor or LIBOR that the bank itself has participated in creating. And so what happens between the traders, who of course are these people who are online with all their chat boxes, and their screens are covered in chat boxes where they've got their mates. And these are the traders at the other banks. And they realize that they've got exposures of millions of pounds or dollars or whatever. And they realize that if you could manipulate that day's rate down a little bit, it might fundamentally affect the amount of money that you will have to pay or receive under a particular agreement that you have entered into. So the traders are incentivized, no doubt they're on unbelievable commissions and all the rest of it, they are incentivized to manipulate what is meant to be a public good. So it's a long way of introducing it, but not everyone's familiar with this concept. Now, suffice it to say, if banks falsify submissions, That's obviously wrongdoing. But it's wrongdoing that normally would be punished under applicable financial services legislation. There may be a market abuse principle. It might even be some kind of conspiracy in terms of criminal law. So there are ways of dealing with this bad behavior. But query, can the same bad behavior infringe Article 101 of the treaty? Is it an agreement that violates Article 101? Well, the banks are in a horizontal relationship, obviously. So in principle, one can see how Article 101 could apply. But they're not in the business of selling LIBORs. They're not fixing the price of LIBORs that they sell to people in the way that Bonduelle was fixing the price of canned vegetables. They've just agreed to manipulate the LIBOR. So query, is that kind of agreement the sort of thing that can violate Article 101? Well, suffice it to say, the Commission said it did violate, and it was an agreement that restricted competition by object. And so this HSBC case is a case that goes to the General Court on the question of whether and how an agreement to manipulate a benchmark, could it be restrictive of competition by object? Suffice it to say, in this judgment, the General Court's conclusion is, yes, there was a violation of 101 by object. For technical reasons, the fine was annulled. We don't need to concern ourselves with that. The interesting feature of the judgment is, how was it a restriction by object? And the court says there are two chapters, as it were, to this story. First of all, there is evidence that HSBC, the appellant in this case, agreed with Barclays Bank that they would actually manipulate the price of Euribor on a specific date, the 19th of March 2007. So there was a horizontal agreement between HSBC and Barclays to make false submissions to Thomson Reuters, because obviously if you're making false submissions and then Thomson Reuters is looking for the average of everything, if you've made false submissions, you can manipulate the day's rate downwards. And even if you're manipulating it downwards by 0.02%, if you're talking about derivatives agreements worth $100 million, that's a lot of money. So query, if you agree a specific day's Euribor, does that violate 101? Paragraphs 78 to 114, yes. Because the value of that Euribor for that day is an element of the price that is paid under the derivative agreement. And 101 applies to agreements to fix prices, but also to do agreements that affect elements of a price. And this is affecting the element of a price. And therefore, it is a restriction by object. But then the other thing that the court says is that these guys, because there's always guys that do this kind of thing, it's never girls, there's always guys in these chat rooms doing, they're all called Rupert and Marmaduke and funny things like that. They, in the course of having these chats, they exchange a lot of information. They just get chatting about their exposure and the kind of deals that they're doing at the moment and what they think they might be doing in the future. So there's a lot of chat that goes beyond, as it were, banter and gossip. They actually start to exchange confidential information with one another. And paragraphs 115 to 195 are about the information exchange element. I'm sure lots of you have to look at this agonizing thing of information exchange very often in competition law terms, and it's a notoriously difficult area. Of course, people chat and they exchange ideas, but they mustn't exchange confidential information. And there's quite a detailed analysis by the court here of what chat was legitimate and when did it go beyond what was permitted. An interesting thing in this case is it's, let's say Barclays talking to HSBC, but very often when it comes to the derivative agreements, they might actually be the two parties to a derivative. So they might be the counterparties to an agreement. And so they say, well, of course we exchange information because we are the contracting parties. But what the court says is, we understand that. So there's some exchanges of information that are necessary to the formation of a contractual relationship. On the other hand, there are other exchanges of information that go to the removal of strategic uncertainty in the market. And when you do that, that's when you're getting into, I was going to say the grey area, the red area, where you're actually acting unlawfully. So that's all very interesting. And as I said at the top of page 5, that's now appealed to the Court of Justice. So in our system, you have a commission decision, appeal to the General Court, which can be on facts as well as law, but then you have a further appeal on law from the General Court to the Court of Justice. And HSBC are taking this to the Court of Justice because they say the Commission and the Court have both got this object restriction stuff wrong. And they don't understand the market and they don't realise that what we were doing was just essential to this kind of derivative markets behaviour. So they've gone on appeal to the Court of Justice on law. And at the top of page 5, I mentioned that Crédit Agricole has just been given permission to intervene before the Court of Justice. Now, this may be too detailed and technical, but I just think it is quite an interesting idea. Crédit Agricole are here appealing to the General Court. The General Court's judgment is being appealed by HSBC to the Court of Justice. But Crédit Agricole down here says the very things that we're appealing to the General Court about are precisely the same points that HSBC is appealing to the Court of Justice about. So we think that the fair thing would be to allow us to intervene in these proceedings up here, because what the Court of Justice says here ultimately will have a very important bearing on what the General Court down here does. That's something that I've never seen happen before, but the Court of Justice has basically said, well, that sounds sensible, so yes, we will allow that. Okay, so that's that one. Now let's move on to the Court of Justice. There's nothing in envelopes, nothing in smart card chips I wanted to mention. So we'll go to the Court of Justice, and the first one there is payment card systems in Hungary. Now, I just don't know, I can't remember whether in Brazil, have you ever had any of these cases to do with multilateral interchange fees in payment card systems? Bruno, have you had these MIF cases? You have?
Sorry, we had. Yeah, we have.
No, I'm just reading an earlier question that I'd missed, actually. Daniel says, question on effects. Well, there's a question there about if, let's call it the effects doctrine. How do the national authorities or the Commission decide whether an international cartel has an effect in the EU or in Germany or whatever? The way I would answer that is to say that the most important judgment ever on the effects doctrine is Intel against the Commission about 3 years ago, because historically the position in Europe was that the EU had jurisdiction where an agreement was implemented in the EU. That was the old wood pulp judgment from a long time ago. And normally, of course, you could have a Japanese cartel But if the Japanese cartel is fixing prices and then invoicing me in the UK, it's perfectly easy to say that cartel was implemented in the UK because that's where the price was charged to me. And so it was easy to say that there was jurisdiction. That left open the question, what if the cartel was in Japan but was not implemented in the EU, but nevertheless it had an effect in the EU? Could there be jurisdiction there? And the Court of Justice always managed to avoid answering that question because there was always implementation of some kind. But let's imagine a collective boycott where all the exporters of widgets from Japan agree not to sell to me in the EU. You can't say that's been implemented in the EU. That just doesn't mean anything. But it's certainly having an effect in the EU because I can't get hold of the widgets. So there's always been this open question, is there an effects doctrine in EU law? And the Court of Justice finally had to answer it in the Intel judgment. I forget now whether that's 2017 or 18, but it's a very famous judgment on loyalty rebates under Article 102. But it's just as important in terms of effects as it is in terms of rebates, because what the Court of Justice said was that behaviour outside the EU is subject to EU law if it produces substantial and foreseeable effects in the EU. And it has subsequently been held that that can mean indirect as well as direct effects. Okay, so Intel is the judgment for you. Okay, then I just asked about the myths. Just on the myths then, I will not go into the horrible technicalities of the multilateral interchange fees that get charged in a payment card system. Suffice it to say, you have a bank that issues a card to me. You have a merchant who accepts MasterCard from me. The merchant then has to go to an acquiring bank to collect the payment from the issuing bank. So you've got a four-party relationship: consumer, merchant, acquiring bank, issuing bank. And the myth is fixed here between the issuer and the acquirer. The legal question being, does that restrict competition? I won't go into all of that. There's several PhDs can be put together on that. The interesting point in this case is that the Hungarian Competition Authority says we've got to decide whether fixing the myth, is it a restriction of competition? And as you know, in Europe, and I just checked your act this morning, you've got similar wording. Article 101 says that you must not enter into an agreement that has as its object or effect the restriction of competition. And every year for 60 years, we get more cases on what is an object restriction. And the battle goes on and on and on. God knows how many lectures in my life I've had to give on object restrictions, but there's always something new to say because different arguments come up. Suffice it to say, on this occasion, the Court of Justice said, we've looked at these myths, we don't like them, we think they restrict competition, but we think they restrict competition by object, and we also think they restrict competition by effect. So they explicitly say these agreements restrict competition by object and effect. And the banks go to the Supreme Court in Hungary, their argument being, surely a competition authority isn't allowed to do that. Surely it's got to say either it's an object restriction or it's got to say it's an effect restriction, but is it allowed, as it were, to back the horse both ways and to say it's an object restriction, oh, and by the way, if it's not an object restriction, it's an effect restriction? So in a sense, that is the simple legal point being asked in this case: is the authority allowed to say a restriction by object and effect? And that gets referred up to the Court of Justice in Luxembourg, and its conclusion in this judgment, 2nd of April this year, paragraphs 33 to 44, is an authority allowed to say object and effect? Answer: yes, it most definitely is allowed to do that. However, I think it's paragraph 43, if the authority says it's an object restriction and it's an effect restriction, then firstly, it's got to explain why it's an object restriction and how the evidence in the case supports a finding of object restriction. And then separately, if it's going to say it's an effect restriction, it's got to explain why there's a restriction by effect and what evidence supports that finding. Because the process of reasoning, the ratiocination, is different to justify an object restriction than it is to justify an effect restriction. So you can't be lazy and say there's a restriction of competition, it's either object or effect, but it's 5:30 and I'm going home, so that's the end of the decision. You've actually got to go the extra distance and explain why it's an object restriction and why it's an effect restriction. It may seem a bit of a funny question even to have asked in the first place, but I've had these discussions with many competition authorities in my time, where you've got some things that are very obviously object restrictions. It's secret price fixing in the cement sector, and whenever we went to meetings, we disguised ourselves as the Marx Brothers and used false names, and we never generated any minutes or emails. Well, this is just, as bad as it gets. Obviously, that's an object restriction. But then you've got other cases, and I'm coming to another one in a minute, the paroxetine judgment, where something looks bad, but is it actually an object restriction? It might be kind of on the line. And so authorities have sometimes said to me, if we say it's an object restriction, but then they also do effects analysis, does that mean that they're undermining their case in some sense when it comes to an appeal? Because they would only have done effects analysis if they themselves weren't sure that it's an object restriction. So how can they then stand up on appeal and say it's an object restriction if actually they didn't have the courage of their own convictions? So is there something just sort of unwise about saying object and effect? And the other point they would sometimes make is, if the whole point of object analysis is because it's so incredibly difficult to do effects analysis, isn't it a bit weird then to do object analysis and also to do effect analysis? So those are the kind of arguments that come onto the agenda. I've always said to the authorities when I've spoken to them, I don't see any problem whatsoever. Because if you've got a very obvious object restriction, of course you wouldn't bother to do effects analysis. If it's secret price fixing in the cement sector, of course you're not going to spend ages demonstrating that the prices of cement is higher than it would have been in competitive conditions. That would be a daft thing to do. On the other hand, you might be looking at a case where you think, I really don't like these kind of agreements. I think they should be found to be restricted by object, but it's not clear yet, so I'll do effects analysis as well. Because if you do that and you get appealed, of course, there's a possibility you might win the appeal on object analysis. Well, in that case, in the future, you'll never have to do effects analysis. If, on the other hand, a court says, well, we understand your point, but we don't think it's quite there, it's not an object restriction, well, you've got the kind of a reinsurance policy that you can still fall back on effects analysis. So it may seem a bit of an odd point, but I think it was a very valuable judgment to have, because I have often wondered about that point myself in the past. Okay, so that's that one. Then let's go to power cables. I did happen to note that Cartier has been doing power cables. So this is one of our international cartels. Most of the appeals are just simply on the evidence and the fines and whatever. And so from that point of view, I don't think they're legally interesting. I would make the point at the top of page 6 that one of the judgments I mentioned there is ABB and the Commission, 28th of November 2019. So A, B and B appeal this case right up to the Court of Justice. Okay, fair enough. Why is that interesting? To me, the reason that that is interesting is that A, B and B was the whistleblower. So in this case, they were fined 0. And yet, X years later, they're appealing the case to the Court of Justice. And they actually succeed in demonstrating to the Court of Justice that the Commission's decision accused them or found them guilty of more than they were actually guilty of. So they did get the decision sort of shrunk as against them. Why is that interesting? Because they were the whistleblower, and they go along and say, we were in a cartel of widgets, and we did the following. We raised prices and we shared markets. And the Commission says, thank you very much. You've blown the whistle, and in due course, they fine them 0. But when the Commission's decision comes out, it says that the cartel fixed prices and it allocated markets, and also there was a collective boycott. Now, ABB never said anything about a collective boycott, and yet the Commission says that's the cartel, and A, B and B were party to it. Well, of course, when it comes to a follow-on action for damages, they are then exposed to any damages claimant that's been harmed by the collective boycott. And yet their argument is, we weren't party to that. So this is not the first time I've seen this, where the whistleblower who's fined 0 appeals a case because of the consequences for the follow-on action for damages. So that makes my point earlier today that in many of these cases, it is about, well, the fine is important, but in some cases, the damages are even more important than the fines. In our trucks cartel in Europe, the fines were about, I think they in the end came to 4.6 billion euros. Well, that's quite a lot of euros. But I have seen it suggested that the damages claims in trucks might extend to 100 billion euros. Well, 100 billion euros of damages makes fines of 4.6 billion look like pocket money for a weekend in Rio. So, the damages claim is an incredibly big part of all of this nowadays. Lower down, I'll just mention a point in Nexons, because some of you would sometimes be involved in cartels that are investigated in the EU, simply to say that the Commission did a dawn raid on Nexons in Paris. And after 4 days, the dawn raid was going on and on and on and on. And the Commission said, we think the sensible thing would be to just take copies of everything, go back to Brussels, everything will be sealed on a hard disk, and then next week we will resume the dawn raid in our Brussels offices. And Nexons basically says the Commission should not be allowed to do that. The dawn raid is in Paris, France, and it should be conducted in Paris, France. Whereas the Commission says, no, let's go back to Brussels. So this judgment is on the lawfulness or unlawfulness of that. And the Court of Justice says it's a perfectly permissible thing for the Commission to do. So just be aware, you might have a client who's been dawn raided in Copenhagen, but eventually that might get transferred to Brussels. When I speak to the practitioners, actually, I think they find this a sensible way of doing things, and you go to a data room in Tourmadou in Brussels, it actually seems to work quite well in practice. Right, so that's that. Yes, I saw about the decision in Carjay's decision. Yeah, power cables. Now then, an interesting judgment is paroxetine. So let me ask again, I just do not know, Bruno, tell me, have you had any of these pharmaceutical pay for delay cases in Brazil, where a patent-owning pharma company is litigated by generic entrants to the market, and then they come to a settlement whereby a sum of money is paid by the patent owner to the generics and they go away? Have you had that experience in...
I myself am not aware of a patent for delay cases at CAD. I don't know if anyone is aware of that.
I'm just pausing in case anyone's going to say anything.
I don't think so.
Okay, no, fair enough. I'll still talk a little bit about this case, though, because there are lots of them in Europe. You know, there's so much antitrust in Europe around pharmaceutical companies at the moment, and it may be a matter of time before you have these cases there. So, of course, you know, the simplistic picture of pharma industries are that the pharma company gets a patent on a drug, and that means it can charge very good prices for its drug, and it has a patent for 20 years. And in a sense, you know, the monopoly price it charges for the 20 years is the reward for the risk that it's taken in developing the drug in the first place. And the share price of a pharmaceutical company is directly related to the patent pipeline. And you might have a blockbuster drug that makes you a lot of money for a long period of time, but then eventually that patent is coming to the end of its 20 years. And then unless you've got some other drugs coming into the pipeline, you're in a bit of a mess and your share price is going to go down. So we've had lots of cases in Europe, and I really do mean lots of cases in recent years, where you've got the patent owner and you've got generic companies here sort of circling the market, hoping to enter the market. When the patent comes to an end, they can certainly enter the market, and prices typically drop hugely when you have generic entry. But also the generic companies might be of the view that the patent should never have been awarded in the first place because the technology wasn't innovative or inventive, for example. And so you get litigation between generic companies and incumbent patent owners, whereby the generic is trying to argue the patent should be cancelled, and then we will compete with you in the marketplace. And then what the Commission discovered, it did a market study, I think in 2007, into the pharmaceutical sector, and it discovered there were lots of settlement agreements whereby people had, generics had started litigation, and then the patent owner says to the generic company, look, if we litigate this through the patent court, it's going to take ages, it's going to cost an awful lot of money, God knows what the outcome is going to be. Why don't we just do some sort of deal? You withdraw your claim, and we will pay you a sum of money for going. And then what the Commission discovered is that the generic companies were entering into these settlements whereby the litigation is withdrawn, the generic company agrees it will not enter the market for X period of time, and the patent owner pays, shall I say, a significant amount of money to the generic, far more than the legal costs of the action, a really nice, juicy amount of money. So that's the incentive for the generic to abandon the litigation. So these are sometimes called reverse payment settlements, where I sue you, but you pay me to terminate the action. Or pay for delay agreements, you might have got the patent eliminated and you could have entered the market, but I'm paying you not to enter the market now. So let's say you have got pay for delay agreements. Are they restrictive of competition? And then if they are restrictive of competition, are they restrictive of competition by object? Now, this particular case was done by the Competition and Markets Authority in the UK. And our CMA said restriction of competition by object. That then went up to the Competition Appeal Tribunal. And the Competition Appeal Tribunal in London was aware that the Commission has done two of these cases. One is called Lundbeck and the other is called Servier. And the CAT in London was aware that the Court of Justice in Luxembourg was now hearing Lundbeck and Servier. And so the CAT says to itself, it's a bit awkward for us to adopt a judgment in this matter, because we might reach our conclusion, and then the Court of Justice in Lundbeck and Servier might say something completely different. And so most of you will know that there is a system whereby a national court can make a reference to the Court of Justice for an advisory ruling under Article 267 of the treaty. So you've got Lundbeck and Servier here, and then the CAT says, well, why don't you have paroxetine as well? This was all done years ago, before all the nonsense of Brexit. So you've got three appeals, or three cases now, in the Court of Justice on pay for delay agreements. And the Court of Justice gave its judgment in paroxetine on the 30th of January this year. So it kind of jumped the queue ahead of Lundbeck and Servier. So the Court of Justice opined on pay for delay, first of all, in paroxetine, sending the judgment to the CAT on the 30th of January this year. Why did this case get accelerated? Because you may have heard that the UK left the EU on the 31st of January. And the Court of Justice was worried that if they sent the judgment to the CAT after the 31st of January, it might be ignored. So the whole thing was accelerated to safely get the judgment back to London before we left the EU. Anyway, it's a very interesting judgment on numerous points, but I'm just going to mention two in particular. And the first one is of general analysis in Article 101 cases. The CAT and the European Commission essentially see these pay for delay agreements as horizontal market sharing agreements. Obviously, I'll have France, you have Germany, horizontal market sharing. Well, is it really any different that you could have produced a generic drug, but I paid you to go away? Is that not market sharing in just the same way? So the Commission and the Commission and the CMA in the UK see these as essentially horizontal market sharing agreements, and therefore restrictive of competition by object. This goes up to the Court of Justice. The first question is this a horizontal agreement? Because we're only going to be able to say it's a horizontal market sharing agreement that restricts by object if the relationship is horizontal in the first place. And the defendant's argument, or the appellant's argument, is, look, in this case, GlaxoSmithKline had a patent. If they've got a patent, that means that if generic starts producing the same drug, they are infringing our patent, and we can sue them for damages and get an injunction. So in those circumstances, how can they be regarded as horizontal competitors? The patent prevents them from competing. Well, of course, that's a pretty killer argument if it's correct. Because if you say they're not horizontal competitors, then all the market sharing restriction by object is impossible to sustain. And so you have a kind of a prior question of characterization, which is, can an agreement between a patent owner and a generic company, can it be regarded as a horizontal competitor? Well, obviously they're not actual competitors. That's the whole point. They're not on the market. But the idea of horizontal competition includes potential competition. So query, are the generic companies potential competitors to GlaxoSmithKline? And that is answered in this judgment from paragraphs 30 to 58. Now, before I give the answer, why do I think this is interesting? Because, of course, if you're ever looking at any cooperation agreement, your client comes to you with the cooperation agreement and says, is this okay? Well, one of the first things you're bound to ask yourself is this horizontal or vertical, or is there no functional relationship between the parties whatsoever? Because, of course, the more it's a horizontal agreement, the more we know that potentially there could be competition problems. So this is pay for delay, but it could just as well be where you get these things like somebody goes out to tender and a number of you get together to jointly bid for the tender. Well, is that a kind of cartelization as a response to the competitive tender? Or on the other hand, are you putting together a whole series of complementary skills between people who could never have competed for the tender? So we're asking ourselves the question again, are these people actual or potential competitors? And it's not always an easy question to answer. Suffice it to say here that the Court of Justice addresses the question, as I say, 30 to 58. And it says, you are a potential competitor in circumstances where there are real and concrete possibilities of, here, the generic company entering the market. Real and concrete possibilities. So the court sets that down as the standard of potential competitor. It's somebody who has a real and concrete possibility of entering the market. And then paragraph 38 says, that does not mean a purely hypothetical possibility. It's got to be grounded in reality, as it were. And yet paragraph 38 also says, however, to be a potential competitor, that doesn't mean that the authority has to demonstrate with certainty that the manufacturer will in fact enter the market. So there are two extremes. It's absolutely certain that they'll enter. Well, that's not potential competition. There's a vague possibility that they might enter. That's not good enough either. It's something in between these two things. And then paragraph 39, it's a statement of the obvious, but they say the assessment of whether there is potential competition must be carried out having regard to the structure of the market and the economic and legal context within which it operates. So it's the whole context thing. And then the next bit of the judgment's very interesting. They say, well, now let's think about these pharma markets where you have patents. What's the context of these markets? Well, the court says the first context is there's loads of intellectual property all over the place, and it's a highly regulated market. And it's also a market in which, when the patent expires or is successfully challenged, prices come down hugely because of the intervention of generic companies. So that's the context. Regulatory, lots of IP, generics have a very important role to play. Then they say, paragraph 43, what we need to ask is, in a case like this, had the generic companies taken sufficient preparatory steps to enable them to enter the market? So, for example, did they possess the relevant technology? Could they produce the drug in question? Had they applied for a market authorization to sell the drug? Because you could get a market authorization in preparation for the day when you enter the market, even though you're still not allowed to enter the market. So is there a real, have they taken steps to be able to enter the market? Next, 45, is there anything that makes entry into the market insurmountable? Is it impossible for them to enter the market? Well, GlaxoSmithKline will say, yes, it is possible. It is impossible for them to enter because we've got a patent. And the court says, yeah, hang on a minute though. In the pharmaceutical industry, there's patent litigation all the time. And generic companies do sometimes succeed in having the patent annulled. So this isn't some kind of killer blow. It's part and parcel of the rough and tumble of pharma markets that generic entry does occur following successful litigation. And then they go on and say, and there's other things that suggest that you are potential competitors. There's obviously one hell of a dispute between you. GlaxoSmithKline have gone to great lengths to reach this agreement with you. Well, that in itself does seem to indicate that there's a potential competitive relationship here. And then the court also says, I mean, it's kind of, in a sense, it's a bit naughty, but it makes sense. And furthermore, the patent owner and the generics entered into an agreement. Well, why would they have entered into an agreement if they didn't regard you as potential competitors? So in deciding whether the agreement is between potential competitors, you take into account that the companies entered into an agreement. And because they entered into an agreement, that's part of the basket of evidence that you're potential competitors, and therefore you're potential competitors. And then the court goes on to say, and it restricts competition by object. So all very interesting. And then the court goes on to the question of, assuming this is a relationship of potential competition, is it the case that this restricts competition by object? And there, the court trots out all the jurisprudence about object restrictions and reaches the conclusion that in principle, it is possible for a paid-for-delay agreement to restrict competition by object, in particular because a huge amount of value was transferred from Glaxo to the generic companies. And the court says it is possible that a settlement agreement can restrict competition by object when it is plain, quotes, that the transfers of value provided for by it cannot have any explanation other than the commercial interest of both the holder of the patent and the party allegedly infringing the patent not to engage in competition on the merits. In other words, the payment itself goes to demonstrate that there is a restriction by object. If the payment simply covered court fees and expert witness expenses, well, that's a different thing. But if it's a big, juicy dollop of money, well, why was that money paid, or why was value transferred? It must be because they intended to eliminate competition between them. So it's a very intriguing case. It's now gone back to our CAT, and our CAT now has to take that judgment and apply it to the facts of the case, and we await judgment. I assume in due course that the CAT will say that this was a restriction of competition by object between horizontal competitors. And in the meantime, the Court of Justice now has to decide Lundbeck and Servier, and our health service is bringing an action for damages, claiming that it had to pay for this drug and other drugs at higher prices because of the pay for delay agreement. So even one of these pharmaceutical cases, it's not the power cables cartel, but our health service still says it has been economically damaged by these agreements. Now, I'm not going to do vertical agreements. I'll start there next time. So I'll stop lecturing now. Bruno has asked a general question. How do you see the decisions taken by the courts being addressed by the Commission in similar cases? Is there clear guidance? Well, I think by the time this is all over, we will have the Court of Justice judgments in Servier and Lundbeck. And as I just said, I think the CAT will also decide there's a restriction by object in the UK. And I mean, I think the cases, they all have subtly different fact patterns. I think an enormous amount of guidance can be derived from the history of this litigation. And every year since 2007 until last year, the Commission published an annual review of the pharmaceutical sector and competition policy, and it required pharma companies to notify it of all settlement agreements between patent owners and generic companies. And what happened is, over the years, the number of these types of agreement has gone down hugely. In other words, I can only assume that the industry has learned the lesson of these cases. Now, I'm sure other things go on, but these kind of agreements apparently aren't happening anymore. So in that sense, from a competition authority's point of view, you know, enforcement has done its job, apparently. Okay, I'm very happy to take any questions or comments if anyone has any.
If anyone wants to speak, just raise the hand that we can free your Michael.
In the meantime, I'm going through all the pages to see who's out there. Ah, there's a question, Raphael. So to go back, Bondwell, you like your vegetables. Is it... Oh, well, I mean, that's absolutely clear in the EU that if you are the first to blow the whistle, then you automatically get 100% immunity, unless you are actually the coercer of the cartelists. But other than that, if you're number one, it's 100% automatic immunity. Okay? There was an earlier whistleblower notice that said, if you blew the whistle, you might get up to 75% of the fine off, and nobody blew the whistle. And then the DOJ in Washington decided to go for automatic 100% immunity. We in Brussels copied that, and that's when all the immunity applications came in.
I think we have another question from Hibas. Is there any investigation involving digital markets?
Oh. Well, I'm saving that up for next time. So if you go to page 9 of my handout, we will find Amazon, Apple, over the page Google, and then I will also talk about the Bundeskartellamt decision about Facebook. So next week will be very much about digital markets, yes. Do I think the EC should issue a guideline on cooperation for sustainability? That's an extremely good question. And it's been a funny situation for a long time that, you know, we have this 1011, 1013 set up, and that if an agreement leads to technical and economic progress, blah, 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 then the agreement is permitted. Now, there used to be a system of exemption whereby you could notify the agreement to the Commission, and it would say, well, it does restrict competition, but it satisfies 1013, so here's your certificate, if you like. But that was stopped in 2004. And so since 2004, we never get explicit positive applications of 1013. All you do is to get cases in which people run 1013 and the Commission says it doesn't work. So I think it's very unsatisfactory, because it's almost as though 1013 has disappeared. And one does need guidance from people as to when you can perform some kind of cooperation. And I've said for years that more guidance is needed. And then, firstly, the sustainability agenda comes along in recent times, and we do face absolute disaster quite clearly. And companies do sometimes honestly want to do things that will be environmentally helpful, but they're anxious. But anyway, that's been an issue. And then the pandemic came along. And of course, various people get together and say, we want to cooperate on medicines or distribution of essential goods. And I know Kaja have done it, but the European Commission and the CMA have started to give guidance on when cooperation between competitors is legitimate in a situation of the pandemic. And so authorities have started giving guidance. Indeed, the European Commission gave the European Medicines Agency a comfort letter, something that hadn't been done for 20 years or so. And then we come back to the sustainability. And I see that Olivier Gerson, who is now Director General of DG Comp, was speaking the other day. I think it was the IBA, but it may have been the ICN. And he actually said, I think it's time we gave guidance on, so I haven't read his speech yet, but as I understand it, he's basically saying, I think we need to give guidance on sustainability agreements. And I think there's a big head of steam building up in favour of this at the moment. And the European Commission has had a consultation recently on, we've got horizontal cooperation guidelines. And there's been a consultation on what needs to be done with the horizontal cooperation guidelines. And the overwhelming reaction has been, help us, especially on sustainability. So I think it's almost as though COVID-19 has kind of helped authorities to overcome their reluctance to give guidance. And I mean, that might be a good, to my mind, that might be a good thing that comes out of it all. And incidentally, I don't think it's only about sustainability, because I've had companies come to me and say, look, we don't want to be buying cocoa from international companies who are horribly abusing the people that work on the cocoa farms in the Ivory Coast. And we'd like to boycott some people because we just think it's improper to deal with them. But we don't want to boycott them unless our peers can do the same. Or we don't want to source carpets from countries that are using child labour. Is it okay to enter in these kind of agreements? Well, your moral conscience tells you it must be okay. And yet at the same time, if you apply certain legal precedents very literally, you can't help but thinking, oh God, that looks a bit like an object restriction. So I think guidance is needed, and it's not only sustainability in the environmental sense. I think there's also something that one could call, ethical agreements, where some types of cooperation might be genuinely motivated by good public policy principles. But I know that lots of companies find this very difficult in practice, especially if authorities apply the law, as it were, into rigid a way. Is the Bondwell case an international cartel? Well, it wasn't an international case in Daniel's sense of the term, because he was meaning cartels that sort of extend from Chile to South Korea. I don't know what happens in North Korea, but this was certainly international within the EU, because I seem to recall that there were French and Italian and I think Spanish participants in the cartel. Then, having cartelized the vegetables, of course, they then get exported to obviously Brazil. Okay, so
I think we've accomplished the agenda for today. Professor. I don't know if there is any other questions, but if not, I think we're going to be back next. Next week's going to be on Thursday, so on the 24th, not on Wednesday, same time, to cover 102. Right.
Yes, we'll have 90 minutes of abuse next week, okay? But I'll also start with a few comments on vertical agreements as well.
Okay.
Okay.
Sounds good. So thanks a lot again in the name of IBRAC. Thanks for everyone, and see you all next week.